Against the background of recent attempts by Chinese company Zhongshan Fusheng to take over several assets belonging to Nigeria abroad, we talk about state obligations and contracts and how they affect the federal government. My guest is a life bencher and the co-chair of the Legal Services Subgroup of the Economic Development Forum, Mr. George Etomi. Also showing on the program, President Bola Tinubu swears in Justice Kudirat Kekereekun as Acting Chief Justice of Nigeria, hours after Justice Olukayode Ariwoola bows out of the bench after clocking the mandatory retirement age of 70. There's a recap of the top stories from the courtrooms. Hello and welcome to the program. I'm Shola Shieli. Sometime last week, the story broke that a U.S. appeal court rejected Nigeria's sovereign immunity defense to the enforcement of a $70 million investment treaty award won by an industrial investment Chinese company in a free trade zone agreement. 3 days after the judgment of the U.S. appeal court, a Paris court in France ordered the seizure of 3 jets belonging to the Nigerian government over the disputes involving the arbitration award to the Chinese firms. There have since been similar reports of moves to seize Nigerian assets in at least 8 countries. The news was received with shock by a large portion of Nigerians, especially against the background of the recent P&ID case. How did Nigeria find itself in this mess? When does a state contract or obligation become federal? What about the sanctity of such contracts? Is there no limit to the kind of assets that are touchable? And how many more of such cases are out there? Why was there a seeming lack of diligent prosecution? And what are the options open to the country? All these and more form part of my conversation with a foremost business lawyer and life bencher, Mr. George Etomi. I began our interview by asking his thoughts on the terms of the contract between the Chinese firm and the Ogun State government and what lessons Nigeria can learn going forward.
Well, the main issue it has thrown up here is how subnationals can drag the federal government into their own issues. First of all, is it possible? Is it possible? Some people think it's not possible. It's possible. But there are 2 principal ways this can happen. It can be done pursuant to treaty, like we found in this case. Or it can be done if the federal government is actively involved in a project in which a state is involved, as in, for example, being made to provide some sort of sovereign guarantees, and we see those also very often. Now, apparently, it was pursuant to this that the Ogun State government, when they wanted to develop their free trade zone, approached this Chinese company, Zhongzheng, who through their subsidiary Zhongfu, now went into this contract to develop the free trade zone. Now, talking about the free trade zone, there's a federal agency, NEPSA, that's involved in this particular case. So that's another way the federal government gets drawn in. And under that treaty, if there are disputes, they can be referred to arbitration. And this is again what happened in this case. Now, that's step 1. Once the arbitral process kicks in, then there is another commitment under Nigeria, under which Nigeria labors, which is the New York Convention for the Enforcement of Arbitral Awards. And that New York Convention is acceded to by about 170 countries. So if you get an arbitral award, you can actually enforce it in any of the 170 countries. Nigeria is a signatory. So it's the interplay of these obligations that suddenly made this even more potent for the federal government to have been involved in what Ogun State was doing, knowing that they were running the possibility of being dragged into this matter.
So I noted what you said about state obligations and how they become federal. But also one of the lessons, as you've also pointed out, is about the sanctity of contracts. What does this say about the sanctity of contracts when one government can come in and cancel the contract that has been entered into by another?
Yes. Now, it's one thing to go into a contract. It's another thing to follow the tenets of that contract. Now, what we see very often in these climes, and it's often has some political tinge to it is that a successor comes in and meets a certain state of affairs, which rightly or wrongly, and I'm not passing any value judgments, they don't like. But there is a process to follow if you want to terminate a contract. You just don't terminate the contract without following the process that's provided for. If you don't do that, it exposes you to the risks we are now seeing. In this particular case, as I mentioned, you cancel. As we now hear, again, no value judgment. The police were used to chase some people, detain some people, and all that. Under this bilateral investment treaty that I talked about, any agency of government, federal, that is involved, that's how they drag the federal government in. If through an agency of yours, it could be the police, it could be the NEPSA and everything, the bigger fish here is the federal government of Ogun State. So they will go for that. So it still requires us to understand that due process is important when you're dealing with international contracts.
I hear what you say about due process, but like a lot of people, I'm also wondering, what does this say about diligence in prosecution? Because Nigeria knew about the arbitration. We knew that these cases were going to end up in court. But what does this say about, our prosecution of these cases?
From what we're hearing in this case, and even unfortunately in the PNID case, there appear to have been some lapse in responding professionally as they should have until the arbitral award was given. In fact, in one of the cases that we saw there, the federal government, I think, rushed into the case, pleaded sovereign immunity, pleaded, said, they tried to challenge the arbitration clause, but for inexplicable reasons, dropped those. So that cleared the coast for them to go ahead to then make an award. So they made an award for $55 million as a principal sum, close to $9 million in interest, $75,000 we're hearing now for punitive damages, at least for what we hear the police handling of some of the workers of Zomfu, and then of course costs. Now, it takes us now into the territory of enforcement. So we now went beyond whether or not an award has been gotten to the enforcement. Again, there was plenty of notice. And even when permission was given, 74 days in the case of Quebec, from what we understand, nothing was done. That period lapsed. Then we came back after the period to apply for an extension. So
is it that there are no consequences, or why do we keep coming back to issues and contracts like this?
It's very troubling. It's really, really very troubling, because we're not talking about small monies here. PNID was humongous. The good fortune we have with the PNID was that we could prove fraud. Otherwise, all the other arguments we put up, give us time, give us days, they were all thrown out. It was on that fraud. The threshold for fraud was high. We did well. We could prove it. If that had not been available, we would have been done for. In this particular case, I don't know whether you can set it aside using fraud. That's the only window that I see that we have. But you could have pleaded it at the beginning, but you can raise it at any time. But again, the issue is, why do we display this degree of crass incompetence and nonchalance, cavalier attitude towards international obligations? Look, as a business law lawyer, I can tell you that we always lose the argument when it comes to arbitration clauses in agreements of an international trade type, because these things affect investment decisions. If they see that if an investor sees that the investments are not protected, nobody's going to come here. So many of those who are bringing in investments are opting. Exactly. In some cases, they even say, let it be English law, not even Nigerian law. Okay, it could be Nigerian law, but enforceable arbitral place abroad. So many of these things tend to undermine our sovereignty. And that's why we tend to be reactionary. The arbitration is going, they can bet their bottom dollar that you will not show up. Yes, you will not do anything. Then the award is gotten, and it's when they want to enforce, it suddenly becomes, oh, who did, who didn't do. But by that time, you start running around. It's not good.
Any reprieve for Nigeria? How do we get out of this one? How do we move forward?
It's a tough one. Like I said, P&ID, we managed to prove fraud. Well, I don't know. The last I heard about this, the federal government is in talks with the Ogun State government. I don't generally follow what newspaper reports are, but if the Ogun State government can prove that it had very good reasons to have cancelled a contract, but they couldn't plead it at the arbitration and it borders on fraud, that could be a way out. It's going to be a long shot in this particular case. The alternative is to try and negotiate, because even when you get a judgment debt, you can still negotiate to pay something lesser. Although in this particular case, you'll be negotiating from a weak position because you're only now showing up because they're trying to enforce. So hopefully they can negotiate their way out of it.
So this also brings me back to what you said about Nigeria's assets and what's attachable and what's not, because who knows how many more contracts of this nature are out there.
I recall the last conversation, one of the last conversations, you'd asked me the question, agenda sorting for the new Attorney General. And I did say that we should do an audit of all these international obligations. How many more of these, the P&ID type, this Songfo type, are in the woodworks we're either not aware of or that can spring a surprise to us? That call is even more important today. Then, secondly, we should begin to limit the ability of subnationals to drag the federal government into their own matters. Federal government should be a bit more circumspect in what they guarantee and what they don't guarantee. And when you begin to put yourself on the line, then make sure you ensure that that state stays on the straight and narrow. Even if you begin to hold some part of its allocations to satisfy the potential of these sort of surprises coming at you. Now, what's attachable and what's not attachable? As I mentioned earlier on, if you have an asset that's used purely for state purposes, like your embassy building, like in this case, the presidential plane, which was why it was released, they could prove that it was exclusively for the use of the president. It can help. So it just calls for us to be overall more diligent as a country. We can't continue with this careless and somewhat irresponsible attitude to international obligations.
Having set an agenda for the AGF, let's round up talking about an agenda setting for the new CJN, because there's been a lot of loss of confidence in the judiciary, which is something that you've also alluded to. And there's also been this statistics about the judiciary being one of the most corrupt institutions. So in terms of agenda setting for the new CJN, what are the things that you think that she should focus on very quickly?
Well, I mean, for the CJN, first of all, I will seize the opportunity to congratulate Honorable Justice Kekere Ekun. She's going to be the second female Chief Justice, and has this general belief that our women folk will put us more on the straight and narrow. So the agenda setting for her is that she has a lot of work to restore the confidence of the judiciary. We were talking from an international perspective, but even internally, in all my 47 years of being called to the bar, and this is perhaps one of the lowest ebbs we find ourselves, or the judiciary finds itself in terms of public perception. Perception is important. There are too many things happening within the judiciary. First of all, delay in the dispensation of justice is a major problem. Secondly, stare decisis, the ability to create certainty in the law. We can't have the apex court give conflicting judgments. We just can't have that. And then we can't have lower courts go against what the upper court has said. And there are no consequences. At the very worst, if you are not happy, appeal. The overall image of the judiciary is being battered. And I think the CJ has a work cut out for her. For the period she's there, she needs to write herself into the history books, because the stabilization of this democracy rests squarely on the judiciary. And honestly speaking, if the judiciary timeously, and like I said, honoring principles of stare decisis, deal with critical cases, they can straighten out the system.
Welcome back. Away from that interview, it's now official. Justice Kudirat Kekere-Ekun becomes the second female Chief Justice of Nigeria, albeit in an acting capacity for now. But before her appointment, the Supreme Court of Nigeria bade farewell to Justice Olukayode Ariwola at a valedictory service in his honor, which attracted justices of the Apex Court, justices of other courts, senior advocates and other senior lawyers, and of course, family and friends of the retiring judge, who exited after clocking the mandatory retirement age of 70. Here are some of the things that Justice Ariwola talked about at that court session.
When I became the Chief Justice of Nigeria, I was concerned about the fact that the rules regulating procedures in the Apex Court were those made 39 years ago. Although practice directions have been issued at regular intervals over the years to meet demands of justice, the substantive rules were still as made in 1985. I am convinced that the rules of procedure of any court are the engine that drives its operation. It is also my view that the rules must be dynamic and contemporary in order to meet the changing demands of both the bench and the bar. It was for this reason that I empaneled the Rules Committee to undertake the arduous assignment of reviewing the 39-year-old rules and the many extant practice directions comprehensively. I'm glad to report to you all that earlier this month, pursuant to the provisions of Section 236 of the Constitution of the Federal Republic of Nigeria, 1999, I signed off on the new Supreme Court Rules 2024. With the departure of His Lordship Justice Amina Ogi in September 2023, the Supreme Court was left with only 10 of us. It was the lot of the 10 of us to wade through the tons and tons of political, criminal, and civil cases that were filed in the Supreme Court. At this point, it will be invidious of me if I fail to commend my 9 brother justices who were with me at this critical point. There was a justice who was so ill that His Lordship was always sitting with a face mask throughout the period. Yet, His Lordship could not afford to be off work, even for a week. I am very grateful to you all for this sacrifice. 11 months ago, Justice Amina Ogi, that extremely brilliant and hardworking jurist, in our valedictory speech, had narrated our surprise that one of the cases that found its way to the Supreme Court was an appeal in respect of 12 goats. Yes, 12 goats were the subject of a matter that came to the Apex Court. What this type of cases do is to clog the system, thereby depriving other important cases from being heard. My lords, it is crystal clear from the foregoing that something needs to be done to ensure that the Supreme Court is not unduly overburdened.
A few hours after that ceremony, President Bola Tinubu swore in Justice Kekere-Ekun in an acting capacity. It was a ceremony witnessed by senior justices, representatives of the other arms of government, as well as family and friends. In her remarks, Justice Kekere-Ekun assured Nigerians that she would work hard to improve public confidence in the judiciary.
That I will preserve, protect, and defend the Constitution of the Federal Republic of Nigeria, so help me God. Chief Justice of Nigeria, my expectation is that we will take the judiciary to higher heights. The reputation that it has, we will improve it. We'll make sure that people have more confidence in the judiciary. And I believe that it's not a one-man job. We all have to be on board. And because we all see where the areas are that need improvement, I believe that there will be cooperation, because we all want to see a better judiciary. A better judiciary is for the benefit of the entire nation. Whatever the shortcomings that we see today, we're all members of the society. So if we want to see improvement, let the improvement start with each and every one of us and our approach to justice. Let us all also have faith in the system, and then we'll also be more particular about the process of appointment. I know it gives a lot of concern, discipline on the bench, at the bar as well. All these things are aspects that we will look into. And I believe that by the grace of God, at the end of my tenure, we will have a judiciary we can all be proud of.
Let's now turn our attention to some other top legal stories in the news.
We begin with the reports that the Supreme Court has affirmed the re-election of Imo State Governor Senator Hope Uzodimma. In a unanimous decision, the Apex Court upheld the earlier decisions of the Court of Appeal and that of the Imo State Governorship Election Petition Tribunal, which sat in Abuja and dismissed the petitions in their separate judgments. Last November, the Independent National Electoral Commission (INEC) had declared Hope Uzodimma, the then candidate of the All Progressives Congress (APC), as the winner of the November 11, 2023 governorship election in Imo State. According to INEC, Hope Uzodimma polled 540,308 votes to beat Samuel Anyonwu of the People's Democratic Party, who scored 71,503 votes, and Ethan Achono of Labour Party, who secured 64,081 votes. But the Labour Party and PDP candidates had alleged irregularities in the polls and went ahead to contest the result at the Imo State Election Petitions Tribunal in Abuja and at the Appellate Court. In a similar manner, the Supreme Court also affirmed the election of Usman Ododo of the All Progressives Congress (APC) as winner of the Kogi State governorship election, which held on November 11, 2023. In a unanimous judgment, the Apex Court upheld the decision of the Court of Appeal. The court upheld Ododo's return after dismissing the appeal of Muritala Ajaka, the candidate of the Social Democratic Party, who challenged the outcome of the election. The five-man panel held that the allegation of substantial non-compliance with the Electoral Act was not proven by the SDP governorship candidate. It further stated that allegations of age falsification and certificate forgery are pre-election matters which ought to have been ventilated at the Federal High Court, which has the jurisdiction to hear such matters. The Supreme Court therefore dismissed Ajaka's appeal for lacking merit. The Supreme Court also affirmed the re-election of Senator Duoye Diri as the governor of Bayelsa State after dismissing the appeal of Timipriye Silva, candidate of the All Progressives Congress (APC) in the November 11, 2023 off-cycle election. A five-member panel of the Apex Court, headed by Justice Lawal Garba, on Friday affirmed the Court of Appeal's decision of July 15th, which deemed Silva's appeal as an abuse of court's process for filing two notices of appeal. Citing the section of the 1999 Constitution, the Apex Court's panel held that the APC governorship candidate has only one right to appeal the judgment of the tribunal and not multiple appeals. The court therefore faulted the APC governorship candidate who filed two notices of appeal to the Appellate Court. In a unanimous judgment, the appeal was dismissed by the Supreme Court for lack of merit. And we round off in Ibadan, Oyo State, where the Economic and Financial Crimes Commission, EFCC, has released the lawyer Philip Tunji Ojo, who had been in its facility. After he was detained, members of the state's branch of the Nigerian Bar Association (NBA) has staged a peaceful protest demanding the unconditional release of their colleague. The NBA Ibadan chairman Ibrahim Lawal, who led the other lawyers, said that the protest became necessary to show their dissatisfaction with what he called the illegal and unlawful detention of the lawyer in the course of his duty and to put an end to the constant harassment of lawyers by the EFCC.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program as well as past episodes. Please also send in any feedback via our social media handles. Don't forget that the week-long annual General Conference of the Nigerian Bar Association begins from August 23rd to the 29th. We'll have details of that on subsequent episodes of the program. I am Shola Sheyele. Thank you for watching and see you next week.